Good morning, everyone. And to continue our lesson on arrest, today we will focus on the provisions of the rules of court. And specifically, it is Rule 113. Now, Rule 113, it's the rules pertaining only to arrest. Now, Rules 113 Section 1 defines arrest as the taking of a person into custody in order that he may be bound to answer for the commission of an offense. Now, this statement presupposes, or this definition presupposes the commission of an offense that was discovered by the authorities, and that person to be held in custody of the police authorities is linked to the commission of the offense. So he has to be brought to custody in order for him to be held answerable to the commission of the offense. Now, arrest is made by an actual restraint of a person to be arrested. This is the form of the involuntary one, or by his submission to the custody of the person making the arrest. So that person voluntarily submits himself. In our ordinary language, it is the person or the accused surrendered to the police officers. Now, there are two types of arrest: the one with a warrant and the one without a warrant. The one with a warrant, it's actually a document, a warrant of arrest issued by the court. Now, in another rule, Rule 112 on preliminary investigation, we will discuss that later, how the warrant of arrest is issued by the judge, the underlying circumstances in the issuance of a warrant of arrest. Now, the warrant of arrest, because of the issuance of the warrant of arrest, that the police officers to whom the warrant of arrest is given has the duty to arrest the accused, and he also has the duty to deliver the accused to the nearest police station or jail without the necessary delay. So these are the duties imposed on the police officers. Now, what about warrantless arrest? Warrantless arrest is mentioned in Rule 113, Section 5, but you have to cross-reference that with Rule 112, Section 7. Again, Rule 112, Section 7, or Rule 112 is on preliminary investigation. Now, you have to look forward to our future lesson on preliminary investigation. And preliminary investigation is one of the steps in having the warrant of arrest be issued. As to the first type, the warrant of arrest, I'm referring to the one with the document and issued by the judge. Now, to continue, there are three types of warrantless arrest. One, in short term, it's in flagrante delicto, in which in the presence of the police officers or a private individual, later you will find out when can an individual be allowed to arrest another person, private individual, meaning not police authorities. When it comes to a person who has committed an offense in the presence of that private individual, and not necessarily, again, I want to emphasize that, not necessarily in the presence of the police officers. Now, number one, we go back to the number one type of a warrantless arrest. The person to be arrested has committed, is actually committing, or is attempting to commit an offense in flagrante delicto. That's the meaning of that. And the second type is a warrantless of arrest, in which an offense has just been committed and he has probable cause. The person who arrests another person, he has probable cause to believe that based on his personal knowledge of facts and circumstances, that person to be arrested has committed the offense. In short term, it is called hot pursuit. Now, the third type is the arrest of an escapee. Section 5, paragraph C, when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another, meaning in transito. Now, again, The three types of warrantless arrest is in flagrante delicto, hot pursuit, and an escapee. Now, what are the limitations in doing or conducting the arrest? The police officers must remember this. No violence or unnecessary force shall be used in making an arrest. And second, the person arrested shall not be subjected to a greater restraint than is necessary for his detention. So, police officers, who are law students who are police officers, you have to take note of this and be reminded of this in the conduct of your official functions. So, I hope in this very short lesson you were able to grasp the definition and types of arrest according to Article or Rule 113 of the Rules of Court. Now, the team thanks the likers and followers of our Facebook page and also the subscribers of our YouTube channel. Please don't forget to hit that or click that bell so that you will be notified when there are new videos uploaded. And our work in progress, our website, I still have to review that because I'm cramped with my office work, but that will be reviewed, and that is one way to cater those Facebook followers and likers and our YouTube subscribers who have troubles with the audio. Thank you so much for listening, and I'm hoping that you will look forward to the last part of the lesson for next week, which we will focus on the definition of arrest according to jurisprudence or according to the decisions decided by the Supreme Court. Thank you so much.